often will provide give that information to the people that we're mentoring if it's necessary, and they will do the evaluation. So yes. Okay. Moving on, handling a special education case. So we're going to talk a little bit about client realities and representing parents. So with our clients are facing a lot of different things: housing, violence, finances, health insurance, food, childcare, disability. There's just a lot of issues that our clients are dealing with, in addition to issues dealing with special education that could be affecting just their everyday life. In income, there's other issues that could be impacting clients, such as income. Your client may work. They may have a job that doesn't allow them time off. They may have a job that doesn't allow them to have a cell phone. They may have a job that that's quick to fire people if they step out of line at any point. They could be a very low wage job. They could be switching jobs. They could be applying for jobs and getting fired all of a sudden. They may not work. They may have children, young children. They may have more than the kid that you have the case with. They may have a disability of their own. They may have mental, as far as disability, they may have mental and physical health challenges that may be impacting them. There's a lot of our clients have public benefits. The certification process can be difficult. They don't necessarily cover the cost of raising a family and feeding a family and housing. One of the things we also do is housing cases, and we know that sometimes the housing is often unsafe, unsanitary, and unstable. And this is just a list here of the poverty guidelines. So for DC, and you can see for families, households with more than 8 persons. If you go through, you can see what the poverty guidelines are. So if you have 8 people in the household, 42,000, and all of our clients are pretty much under the poverty guidelines. So, group exercise, initial client meeting. So when you have a client, the first thing you're going to do is have an initial client meeting. You're going to meet that client. And let's imagine that you have a scheduled meeting with your new client to be held at your law firm's office. Your client does not show up for the meeting. You cannot reach her by phone. What do you think? How do you feel when the client doesn't show? Yes.
A little frustrated, but to your point, you don't really know what's going on in that client's life. So there could be a lot of extenuating circumstances. Maybe they can't leave work, maybe they can't communicate, they could have something going on.
Exactly. Right. Yeah, there could be a lot of different things. Yeah, I think naturally, when you're waiting for a meeting, you're thinking, where are they? They're not here. I just tried to call them. We had a set. I talked to them last night. I talked to them an hour ago, and they're not here. But yes, there could be a lot of different things that are going on that cause the client to miss the meeting. And like you said, there's a lot of circumstances. Can you name, what are the possible reasons your client might not make a meeting? Yes.
Their childcare fell through for your other kids.
Childcare, that's one. Yep. Overtime. Yes. Metro. Yes. Yes, Metro. What about they don't have money to take the bus to where you are, and they don't really want to say that to you? Or what if they take the bus and they're coming from, Minnesota Avenue, and it's going to take them 2 hours to get over to where you are because of the bus stops? Other issues that may be impacting clients' education. Your client may not have graduated from high school. They may not have basic literacy skills, and they may have, been provided the information that they need. They may not have been provided the information they need to advocate for their children. Other stressors, your client may have responsibilities for extended family members. They have to rely on public transportation, like I talked about. Not be safe in his or her own home or neighborhood. There's a lot of different things. I think I have clients that go across all of these things. They may just not know how to communicate. You know, there are barriers to communication via phone or face to face. They have an inflexible job. Let's say you talk to them and they have cell phone minutes and their minutes all used up. Let's say that you talked to them yesterday and then today their phone's turned off. So there's a lot of different things. They could be caring for a relative. There could even be more serious things. Sometimes we've had clients like, where have you been? You know, we haven't talked to you. And they've been in the hospital for some reason, or their child passed away. There's a lot of different things that could be impacting. Yes.
I just have a basic question. I'm not in the law from the federal government. So when you meet with, where do you meet them? I mean, do you just, how does that handle? Because I'm not sure they can come into my office.
Well, you can always meet. Sometimes we meet at the library, at the local library, wherever they are. We've definitely done meetings there. I think sometimes we've had people, like, if you wanted to meet, I think that's possible that you could meet at our office, but I would have to double check. Your mentor could help you with that. But yeah, she's shaking her head no. So, library.
Right.
Yeah. See, I was wrong. I totally. Yes. There you go. So yes.
Thank you.
So, but also, clients may also come to you frustrated and confused. They might be frustrated with the school. Sometimes the child, they may not understand what's happening. They may be overwhelmed by other stressors. They may seem angry at you, but really they're just angry at the situation, and maybe they are fearful about the situation, and they don't know if you're going to be nice to them or not, or if you're going to help them or not. A lot of our clients have dealt with, unfortunately, a lot of our clients have dealt with when they're dealing with interfacing with other people that are supposed to help them. Sometimes they don't. Sometimes they're rude. Sometimes our clients are just in so much despair that they just expect someone to be, so they're defensive, so they just have a lot of different things going on that they come to you with. And you want to make sure your client knows how to contact you. When you're reaching out to the clients sometimes don't know. Yes.
I was just going to ask, if you have a client that brings you a separate legal problem, because you're helping them with this issue and now I'm being evicted from my house or something like that, are there resources we can refer them to? How do you handle it?
Yeah, so the question is, what happens when the client brings other legal issues that you're not helping them with and wants help with those issues? I mean, I think the first thing is that you make sure that they understand that, like, you can't help them with those issues, but we do have resources that we can refer them to. And if, like, I've had some attorneys that I've mentored that are like, these are the other issues that are going on. Sometimes it might be something that, if it's an issue that Children's Law Center helps with, we might be like, okay, well, we'll take it back in-house. We've definitely taken cases. If there's, like, let's say that there's a housing issue, they're going to be evicted. You're helping the client. We can maybe help them with the housing case. If it's something like a personal injury issue or something that we don't handle or that we wouldn't take on or we don't have the capacity to take on, we can provide legal resources to recommend to other places. But you make sure you know how make sure your client knows how to contact you and how the client should be aware of how you're going to contact them. Sometimes you might have to, tell them in basic terms. Like, I've had clients where they're like, I've called you and called you and called you. It's like, did you leave a message? No. They don't necessarily know. Like, if you're going to call, make sure you always leave a message so that I know that you called. So you might have to tell them and they're like, oh, okay, that's okay. I'll do that next time, or I called you 15 times in a row in the past hour, you never called me back. You may have to establish that, hey, if you call me, I'm going to get back to you. I'm going to get back to you within a day, or I will get, you have to maybe establish those things about what is communication going to look like. If you might want to tell them, like, hey, if something happens at school, tell me, email me or call me. Let me know if something happens at school. If the school tries to meet with you without me, call me and tell them you don't want to meet. So you might have to be very specific about how you want communication to happen. How do you want them to share things with you, and but bottom line, like they need to know how to get a hold of you, and you need to be able to get a hold of them. If they're not available, like, can I email you? Do you have, some people have email, some people don't. Some people say, I don't even know how to use email. I have a client that can't read. So you just have to think about what's the best way for your clients. Yes.
So kind of along that same point, once you're involved, does the school have an obligation to communicate with you? I mean, the way in litigation, once your client is represented, they can't, like, you have to be involved, but can things be going on between the school and the parent without you?
Yeah, the question is, once you're involved in the case, does the school have to communicate with you, or can they just continue talking to the parent? Yes, they can continue to talk to the parent. Because the kid's at the school. So that's why you want to make sure that your client is aware, like, hey, I'm your attorney now. What I normally do is, unless it gets really adversarial, I will say, if they ask you anything about the special education, let me know. Or if the school, I had a client where the school kept trying to meet with my client, like, they knew she had an attorney, but they kept they would lure her into a room and be like, she'd get in there and there'd be a whole MDT team there, and she's like, they're trying to meet with me. So in this situation, you might tell the school, please don't, all communications, include me on those communications. Those are things you can do to make sure that you're involved. But you also want to make sure the client knows that you're their attorney and you want to help and you want to know what's going on, so that they still can communicate though with them.
You have to communicate with the client, not the school. Or can you call the school and say, I want you to communicate with me?
Yes, you can tell. You definitely can tell the school, I want to be included on all communications. You can't tell the school, don't talk to my client, but you can say, I want to be included on all the communications. And certain things you may not want to know, like if kid's going home early because mom's picking him up because he has a birthday party. Certain things you don't need to know. So you want to make sure that, and the school would be like, you don't need to know, that, but you do want to be included on anything related to a special education case or things like that, or discipline. So we talked about finding out all possible ways to contact your client. Talk about, written and spoken correspondence. Explain verbally anything you've sent to your client. Check for understanding. Did you understand what I said, or what do you think about what I just said, or did I explain that okay? You want to make sure the clients understand. You want to make sure that you ask that and make sure that they agree, that they understand, not just like, okay, this is what's going to happen. Okay. You want to make sure that they are clear on what you're saying is going to happen next. You try to keep written communication at an 8th grade level. Discuss how you and your client will stay in regular communication early on in your representation. So first steps. When you take a special education case from Children's Law Center, you will receive all the information, every document we were able to gather during our intake process. You will receive an intro email from us, and you'll also get notification of who your mentor is, the mentor that's assigned to you. And CLC will reach out to your client to notify them. Once you get the assignment and your conflicts are cleared and you're ready to go, you want to contact the client as soon as possible to schedule the initial meeting. You want to ask them to update you on anything that happens with the school, like we just talked about, including if the school wants to schedule a meeting. That's another thing, very, very important, because the meeting thing with special education is huge. That's where things go down. That's where advocacy happens. That's where rights are asserted. And so you want to make sure that you are involved in those meetings if it really pertains to what's going on with what you're doing in your case. So as far as scheduling goes, the law says that, say you're scheduling an IEP meeting, it has to be at a mutually agreeable date and time. So the parent and the school have to both agree that this time works for you. As the attorney, you want to make sure that the parent is not scheduling meetings without considering your schedule. So that's something you want to make sure that you're clear on up front, that you want to let them know that you want to be a part of that meeting, and that you need so that as far as scheduling goes, you want to make sure that you know so that you can work with your schedule. Because technically schools can say, schools, if they really want to be difficult, if you say, I can, like if your client says, I can make it, but you're like, I can't make it, the school might be like, well, we don't care about whether you can make it or not. We care about whether your client can make it. And as long as the parent is available, we're fine. So you don't want to get into that. You want to be as a team, you and your client, we're available on this particular date and we both can make it. So you want to make sure that they are including you and talking to you, as far as scheduling. Consider transportation and logistical challenges for the client. Consider whether the client needs funds to get to your office. You want to make sure that you consider let's say when you schedule your client meeting, you want to make sure that, you're clear on, is that okay? Will you be able to make it? Will you be able to get there? And ask them that, because they might say, do you want to schedule a meeting tomorrow? Yeah. Okay, well, we'll see you then. And they might not even be able to get there. So you want to make sure, is that okay? Does that work with you? Can you make it to, this meeting to talk about your case? Meeting basics: sign the retainer and release in the initial meeting, review and sign the retainer. You will want to explain what it means to work with the lawyer. You want to talk about the confidentiality, the relationship, long and short-term goals, importance of staying in contact. You want to make sure that it's clear that this is client-driven representation. The client is the boss. Sometimes clients will say, once you start representing them, well, whatever you think is best. No, that is not acceptable. The clients have to direct representation, and don't think that they can't. They are capable of telling you what they want to happen, what they, want for their child. And I always tell them, like, this kid better than anyone, and I sometimes tell clients, they're like, I'm not sure. We'll talk about the options. I'll say, call me back tomorrow. Think about it. We'll talk about it some more if you have more questions, but you want them to be the boss and direct representation and to do what they want to have, to do. And you also want to listen to them. If they say, they want a certain thing, if they want their child to go to this particular school and they think that's going to be the best for the child, and it's, it's something that you feel like you're going to advocate for, you want to make sure that you're listening to them and not say, well, I think this school over here is actually more appropriate. If they're like, this is the school I want to go to, then, they are directing the representation. So you want to make sure you're listening. Use simple language, discuss who will communicate with the school, be explicit about when you want them to communicate with you. And so the training manual has some suggested topics for the first meeting in tab 1. And then now we're going to go on to IEP meetings before the meeting. So before the meeting, you should be requesting records 5 days before. If you're going to discuss, let's say you should be discussing, you should request the records, and then you should review drafts and evaluations and discuss with the client. Determine whether or not you want to invite additional participants, and you want to prepare your client. So requesting records, you want to request the records from the school 5 days ahead of time. You want to look at what they provided to you, and you want to determine, do you want your child in the meeting? Do you want this general ed teacher there? And you want to prepare your client for how you want to make sure that the meeting runs. When you have a meeting with the school, I guess I'll get to that. Before the meetings, request records. So you should try to ensure that you have all the relevant records prior records in the case prior to that meeting. The schools are required to provide parents with copies of documents to be reviewed at the meeting at least 5 days before the meeting. You want to email the school 5 days before if you haven't received the records. If the school provides the records, you can ask for the meeting to be rescheduled, but weigh pros and versus cons. So let's say you're going to have an IEP meeting. 5 days ahead of the IEP meeting, you want a draft of that IEP so that you can look at it ahead of time. If they don't give you that draft IEP ahead of time, you can, by law, they're supposed to give it to you 5 days ahead of time. So you can decide, do I want to have the meeting rescheduled, or do I want to just go and have this meeting anyway? And that's really a matter of strategy. Does it make sense to go ahead and have the meeting? Do you really need it 5 days ahead of time? And sometimes you might want to say, no, I need it 5 days ahead of time. I'm not going to sit at a meeting and try to review this IEP at the same time of you going over it. I need it 5 days ahead of time. So let's reschedule the meeting. However, if you're in a situation where the meeting's been rescheduled multiple times, and it's just stalling out, you might decide, let's just go to the meeting. We know it's going to be an inappropriate IEP anyway, and let's just get the ball rolling. So it just depends on, what's best for your client if they fail to provide their records. So reviewing the records, you want to review these evaluations. If you have evaluations, if you have IEPs, you want to review this stuff before you go to a meeting. You want to look at the recommendations. You want to look at the source of information, compare prior evaluations if you have them. You want to look at the IEPs. If you have more than one IEP, if you have a 2016, 2017, 2018 IEP, you might want to just take a look at these IEPs and see what the hours are, correspondence between baselines and needs, same goals, different goals, anything in the IEP that could be applied. If the kid has an IEP from 2015 and the kid has an IEP for 2019 and they have the exact same goals, there's a chance this kid is not making progress. So there should be things should not look identical. So that's a red flag. So those are things that you want to look at. You want to look at hours. If this kid is being suspended multiple times and you look at the IEP, the draft IEP, the old IEP, and there are no counseling services on this IEP, those are things you want to look at. That's a red flag. Eligibility and placement documents. Has this been completed before a team meeting? Has this information been reviewed? Do you need other participants? Do you want an educational consultant there? Do you think you might need that person because you might be gearing up for litigation after this? Do you want a psychologist or evaluator? Is that like if it's an IEE, do you want the person that did the evaluation to be there to explain their evaluation? Do you want someone there to take notes? You probably want someone there to take notes, I will tell you. And other individuals knowledgeable about the child. You might want the child there. Sometimes, especially in high school, sometimes the kids can provide helpful information if the kid says, hey, this special ed teacher, I don't even know who that teacher is. That's helpful information and it can happen. So you want to think about, do you want the child there or not? Prepare your client. This is really important. You want to review records with your client and discuss the purpose of the meeting. Checking with your client before the meeting. If other issues have arisen, you want to talk about those. You want to know what the client's goals are for the meeting. You want to agree. You want to agree with, how's this meeting going to run? Am I going to start talking first, or are you going to start talking first? Are you going to talk and then I'll wait and then I'll add in afterwards? You want to establish those things ahead of time, and you want to know how to handle it if you want to speak with each other, like outside of the meeting. You also want to prepare your client. If you know that it might be adversarial and your client is already pretty frustrated and at the end of their rope, you want to prepare them ahead of time so that, because you don't want to get to the meeting and the client has an outburst. You don't want to get to a meeting where a client gets kicked out of the school and police are called. You want to prepare your client ahead of time. Hey, the school, they always do stuff that's annoying, and I know they're really annoying, but we're trying to help you. So if you get a plan, if you feel frustrated, write me a note or step out of the room and we can stop and take a break. You want to establish those things ahead of time. And then you want to talk about the client's goals. What do you want to happen? You don't want to get to a meeting and you thought the goal was to get an independent evaluation, and the client gets there and says, you know what? I love everything the school's doing. I just love it. You want to know ahead of time so that you're not surprised. And I think any attorney that's done this for a while has had that happen. And it's like, what? No, stop talking. But something like that does happen. You should stop. You feel free to be like, can I talk to you outside for a second? I have done that. And let's go talk outside, and then let's regroup and figure out that's so you can do that. But if you talk ahead of time, you'll have less, it's less chance that will happen. So you want to discuss your advocacy style. Are you going to go in there, aggressive and pounding the table? Are you going to be calm and serious? You want to tell your client, this is what you're going to expect from me. Because if you go in there and you are an attorney that keeps your cool and you don't, but you know what you're doing and you're getting everything, your client might be expecting something they've seen on TV. You're like, why didn't you yell? Why didn't you say this? Why didn't you do, so you want to let them know, this is what I'm doing, and this is why it's important. This is why it's okay that I'm doing things this way. And you also want to discuss transportation logistics. During the meeting, do's and don'ts. Do's for the IEP meeting. Do let teachers and school staff provide updates on the child's progress from their perspective. Make sure you're taking notes on what is being said. Do ask for names and roles of participants if they aren't made clear at the beginning of the meeting. Make sure you know who's in the room with you. If someone comes and sits down and just is sitting there taking notes, find out who they are. Excuse me, who are you? And, because this was the IEP meeting called by, this is the parents' meeting technically for their child. So they need to know who's participating. Ask for a break. Do ask for a break or time to speak with your client alone as needed. Don't be afraid to ask questions about acronyms, goals, meeting purpose. When you go to an IEP meeting, sometimes the attorneys we mentor are like, I don't know what I'm doing. I don't even feel like qualified to be in this room with these educators. I don't want to ask too many questions. I don't know what I'm doing. No, feel free to ask questions. You can ask questions two ways. One, you could just ask, like, what does IEP stand for again? Don't be confident in whatever you ask. Sometimes I've asked questions and, the school will huff and puff about it. It's like, no, can you just answer the question? I've had schools say, I already I said that already. Well, can you tell me again? Don't be afraid to ask things. Also, you can say, if you I should probably know that, but I don't. What you can say is let's say you're going through an evaluation. Can you explain, to a psychologist, can you explain what the cognitive levels are? Can you explain that to my client here? And, because your client needs to know too, not just you. So if you know what, some test is or what a standard score is, have them explain it. I am not, don't be afraid to say, explain this to me or my client. I don't understand what you mean. Don't let them intimidate you or your client into not asking questions, because the more questions you ask, you're going to get information. So feel free to ask questions, even if you feel silly, like you should know it, it's fine. Don't sign overly broad documents without editing them. So one way, this small way, is like a prior written notice. We talked about prior written notices. They'll have, let's say you have a prior written notice, and the prior written notice, like I said before, is supposed to say what the actions are being taken by the school, why they did them, why they didn't do them, and what they did instead or what they didn't do. So, for example, a prior written notice, let's say you're having a conversation about placement, and the prior written notice may be written and says, IEP team agrees that change in placement is not necessary. Well, really, it's the school making that unilateral decision. So you want to edit that and say, no, school says, school IEP team, parent does not agree. You want to make sure that you're clear, because you wouldn't want to get down the road to a due process hearing and say, it says IEP team, because IEP team includes parent. So if parent doesn't agree, you want to make sure it's clear in documentation that parent does not agree. And it's not the full IEP team. It's just the school making the decision. Don't leave a meeting you disagree with without making sure your disagreement is somewhere in the notes. If you disagree with something, say it out loud. Feel free to say, I object to you not evaluating this child. Someone said to me once, why would I say objection? You have to let the school know some way that you don't agree with what they're doing. And you want to make sure that they know in a meeting. You don't walk out of a meeting and you disagree, but you didn't say anything. Because what will happen is, if you go to a due process hearing, they'll say, she didn't say she didn't agree with that at the meeting, and her attorney was right there next to her. And, so you want to make sure that it's clear, that you make it clear that if you disagree with something. Post-meeting advocacy. After the meeting, debrief with your client. Memorialize meeting notes and points of contention. Follow up on outstanding issues. When you end a meeting, you want to talk to your client. Maybe not that day, maybe the next day, or maybe that afternoon. How did you feel about that meeting? That's what I normally say. What did you think? Get their opinion first. I think it was okay. I felt pretty good about that. I worried about that, and then see where oh yeah, I did too. And then talk about the meeting. What are our next steps? So you want to make sure that after the meeting that you talk to your client. You don't just want them to go home and they don't hear from you. Checking with your client about how they feel the meeting went, whether or not they feel heard. The next steps, like I just said. Post-meeting debriefs are a good time to counsel clients on legal rights versus goals, pros and cons of litigation, if appropriate. If you think you might be going to a due process hearing, or you think that that's on the horizon, you want to talk about those types of things as well. Memorialize concerns. Consider writing a letter after the meeting to document your own notes. Ask that a letter be made a part of the child's special education record. Examples of letters are available in the Pro Bono practice manual online. Like, I would definitely recommend looking into letter writing, as we'll talk about in a minute, is key to memorializing concerns and what types of things took place at a meeting. Set a tickler in your calendar to follow up on items promised after the meeting. This may also help build your record for a hearing if there has been follow-up but no response. When do special education cases end? You're not their lawyers for life. You're not on retainer just forever. There is a cutoff. These cases are meant to end at a certain period. We're not just going to be, on these cases forever. And these are the types of things you want to consider when you're closing, when you decide to close a case, and one of them is there's no remaining active legal issues. There's no outstanding legal issues, close the case out. If the child is changing schools, and they don't need, child is changing schools and there's no legal issues. If child is changing schools and there's legal issues, you might stay on. But if they're changing, let's say they're moving to Prince George's County and they're not going to be, needing your help anymore. Communication issues. If the parent, you're not hearing from them, then the case might need to be closed out. If they have disappeared and you can't get a hold of them and it's been months and months and meetings have been missed and things like that, we can talk to your mentor about it, but that's something to consider whether you need to keep the case open or not. When you close your case, when you have to close your special education case, times when the child has moved to another state, like I just said, or a client is out of contact. How to close your special education case. Schedule an in-person meeting with the client to review case and case goals. Use the meeting as an opportunity to review client advocacy skills and possible issues that may come up. And then after the meeting, you want to make sure that you send a closing letter. And there are samples in our guide. So, we're going on now to the